Hi, I'm Shannon Farrell with the OSU Department of Agricultural Economics, and in this video in the Farm Transitions video series, we're going to talk about the legal requirements for executing a will and the probate process. And this is important to understand because you need to understand where the will fits in the estate planning process and the legal technicalities of executing a will and actually getting it carried out through the probate process. And as we're going to talk about several times, the will has to go through the probate process to have legal effect. It's not enough just to have the will and that everyone knows what the will says. It actually has to go through the legal process of probate because that's how the will gets its legal power to transfer title and property from your estate to the person that we mean to receive it. Now, what a will is pretty straightforward, actually. A will is simply a set of instructions for how you want your property to be distributed once you pass away. No more, no less. It's just that set of directions for how we go about allocating that property. Now, importantly, it's got no legal effect whatsoever until the person that made it, we call them the testator, the person writing the last will and testament, passes away. So you can change your will as many times as you'd like, so long as you've got what we call testamentary capacity, which we'll talk about in just a little bit. But it has no legal effect at all until you pass away. So remember, no legal effect means that if you've given someone property in your will, they have no claim in it at all whatsoever until the will is given effect by the testator passing away and it going through the probate process. Now, if you're an Oklahoma resident, if Oklahoma is your home, then your will has to be probated in Oklahoma court. But also, if you own property in other states, the will is also going to have to be probated in those other states for it to change title to that property as well. Now, before you make a will, you've got to have what we refer to as testamentary capacity, okay? You have to have a mental state of awareness that the courts will deem as sufficient for you to engage in something as important as executing a will. So, what does that mean? It means that you have to be able to understand, first off, the nature and extent of your property. In other words, you have to understand what you own and how much of it you own. It doesn't mean that you have to have your personal inventory memorized, but you have to have an idea of the kind and amount of property that you have. You also have to understand who would receive your property if you didn't have a will. Now, in other words, that means you have to understand who your family is, because if you don't have a will, your property is going to go to a surviving spouse and or children or perhaps siblings, parents, if you don't have a surviving spouse. You just have to have an awareness of that. You also have to understand what you're doing. In other words, you have to understand that the action that you're taking is that of making a will. And you have to understand how all of these things fit together. In other words, you have to understand that you're making a will that causes your property to go to the people that you've specified, and that if you didn't have a will, the property would go to the people in your family or your other heirs as they're defined by the intestate statutes. That's kind of an important standard to have. And so what many attorneys have now taken to doing is perhaps videotaping your execution of the will so that they can document that you do have testamentary capacity. Now, testamentary capacity is important, number one, because you can't execute a will without it. But number two, if someone doesn't like what they've received under your will, they'll probably attack whether or not you had testamentary capacity. Now, testamentary capacity can be affected by a number of things. And the three big categories that we always talk about are undue influence, fraud, and mistake. Now, if we talk about undue influence, we mean that there was someone in the person's life that was capable of exerting enough personal influence on them so that they executed a will that didn't really reflect what they would have done without that influence. Lots of times, if there is a child or a spouse that was a caregiver and the testator was very ill, other people might argue that in that person's weakened state, the caregiver had undue influence over that person. Now, that doesn't mean that was the case, but that's what lots of people may sometimes argue. So again, it's really important that you document that you had testamentary capacity to make sure this isn't an issue. Fraud is pretty much what you think fraud is. This is someone basically causing the testator to execute a document that is a will by telling them it's something else, like for example, some other sort of agreement or contract, or someone lying to the person making the will, the testator, to get them to execute a provision that they wouldn't have executed had they not been told the lie. Again, this is something that's sometimes raised during those contests. And lastly, mistake doesn't mean that there was any sort of negative influence by another person. It just means that the person made a mistake with respect to their property or to their family or anything like that. And lots of times mistake may be alleged if the person was ill at the time that they made the will and may have had some mental lapses. But these are all things that we really need to be careful about. We need to make sure that we make a will when we're in a good state of health and a good state of mind. That minimizes the opportunity that we have for contests based on testamentary capacity. So capacity is perhaps one of the most important reasons to not put off a will. If you're in good health and good mental shape right now, that means now's the time to really start thinking about these issues. So that's the capacity. First off, we have to have capacity to execute a will. Then, once we actually have the provisions of the will written down, we have to execute it. And this is basically almost a little ceremony, because this is a really important provision. It may be perhaps the most important legal document that we ever execute. And so the will puts a number of restrictions on what we have to do to effectively execute a will to make sure there's no opportunity for wrongdoing. So first and foremost among those provisions is that every will has to be in writing, and that's why we've really emphasized that in this part of the presentation. Your will has to be in writing to have legal effect. There's no way around it, okay? Secondly, the will has to be signed at the bottom. Any provision in the will below the signature line has no effect. So if you realize that you forgot something and scribbled in at the margin at the bottom, that's not going to work. You need to execute an amendment, which we call a codicil to the will, or start over, okay? Next, you have to have witnesses sign the will as well as you. Now, we say that these witnesses have to be disinterested, and what we mean by that is that your witness can't receive anything under the will. If they do, if someone signs your will and they're also receiving property under it, they run the risk of being excluded from your will. This is perhaps one of the biggest reasons why we have a lot of problems with folks that do fill-in-the-blank forms or that use a legal website. They'll fill out their will and then they realize that the form requires them to have the signatures of 2 witnesses, and so they'll get people around them. Well, the people that are around you at home are often your family members, which are also people that you usually include in your will. That's where we start to see the problems. So make sure that the people that witness the will are people that are not receiving anything under the will. Next, the person that made the will has to acknowledge the will. They basically have to identify it as being the document they intended to execute. And then the witnesses have to sign the will in the presence of the person that made it and at their request. Now, in addition to all these requirements, what many attorneys will do is create what we call a self-proving will. Now, the reason that they do this is because if we didn't have a self-proving will, whenever we did probate the will, we'd have to find those witnesses that signed it, bring them into court, and have them testify, yes, that was me, yes, I saw the person execute the will. And that can be really problematic. What if our witnesses can't be found? What if our witnesses have passed away? So what a self-proving will does is it includes a notarized affidavit. An affidavit is just a sworn statement on the part of the witnesses attesting to all those facts. So that now when we probate the will, we just have to provide the will and we provide the affidavit. That provides the testimony as to the authenticity of the witnesses, and we can move on without having to call the witnesses actually into court. Saves a lot of time, saves a lot of trouble. Now, we've got a will, it's been validly executed. How does it actually get legal effect? What does the probate process look like? Well, step 1 in the probate process involves the death of the person that made the will, the testator. Now, once that has happened, because remember, our will can't have any legal effect until we've passed away, then that will is presented to the county court in which the person resided. So if a person resided, say, in Payne County, Oklahoma, that was their permanent home, that's the district court where we'll file their will for probate. One of the first things the court's going to do is confirm the validity of that will. They're going to make sure that all the execution requirements were taken care of, and that self-proving will, again, will be very important in that. Now, after that, what we do is appoint the executor. And like we've said in other videos, an important provision of the will is selecting who the executor is going to be. Once the court has reviewed that provision, found it to be valid, that executor is given the powers by the court to carry out the estate. And one of the first things they're going to be required to do is to inventory the estate, determine everything that the person that died owned or had control over at the moment that they passed away. They're also charged with figuring out who owed money to the estate and who the estate owed money to. because all of those folks are going to have to be taken care of as well. And last but certainly not least, as we've talked about in other videos, the executor is supposed to preserve the value of the estate, manage it, take care of it until the probate process is completed and the property is distributed. The next step involves the executor taking care of the creditors of the estate. So the first thing that they'll do is mail notice of the probate to the creditors. They'll have to identify the creditors and their address and send a notice to them stating that the person has passed away. They believe that that person owed the creditor some amount and that the creditor is obligated to come before the court to confirm the validity of that claim. Also, the executor has to publish notice of the probate in the local legal newspaper so that any creditors that aren't known at least have a chance of knowing that the probate is ongoing and have a chance to make their claims known. Now, all those creditors, like we said, have an obligation to come to the court, present their claim, and have the claim verified by the court. If they don't, their claims are excluded from the probate and they're not going to get paid back. So all those creditors have to come and verify that their claim is valid if they're to be paid out of the proceeds of the estate. Once all that's been taken care of, now the executor actually carries out the remainder of the instructions in the will by giving property to the people that are specified in the will. But before that can happen, you have to have what we call a final accounting. Remember, we had an initial accounting with the court to say, okay, this is the inventory of property that the person owned or controlled when they died. We've probably engaged in some transactions in between that point and now, so we have to account for those transactions, and then we provide a final inventory to show what's left. This is important for a couple of reasons. First off, it's important to assure the heirs that they're receiving their fair amount of property, that nothing's gone missing. The flip side of that is that this accounting also protects the executor. It proves that the executor hasn't engaged in any wrongdoing, no property's been mishandled or missing, and it exonerates basically the executor from having any other obligations to the heirs. Now, once that accounting has been approved by the court enters what we call a decree. That decree is the court order that says the will was valid, the executor has done everything they're supposed to do, and based on the instructions in the will, these pieces of property are to be received by these specific people. Now, that decree is critically important because that's the document that legally transfers title from the person that owned the property to the people that are going to receive it. And so everyone who received property needs a copy of that decree so that they can go and make sure that the title is then transferred to them. Now, in the course of all this, we've talked about the requirements of execution. We've talked about the actual steps in the probate process. One thing we also need to talk about is when someone doesn't like what they received under the will. And almost always, by statute, the person that has the power to contest the will is someone who would have received more property under the intestate succession rules than they received under the will. So that's almost always going to be a surviving spouse or a child. Now, if someone is attacking a will, they're likely to use lack of mental capacity. We've already kind of talked about that. Undue influence or duress or fraud. Improper execution of the will. In other words, those execution requirements that we talked about weren't fulfilled. Those are the things that people will often use to attack a will. And again, only people that could receive more property without the will are allowed to contest the will. The reason that we talk about will contest is to underline the importance of, number one, making sure that those execution requirements are fulfilled, and number two, that you talk with your family about the provisions of your will. The less surprised they are by those provisions, the less likely they are to have a negative response when the will's actually executed. So having a discussion with your family about the will provisions before you execute the will can actually be a tremendously important step for you, making sure that will contests are minimized or eliminated. Now, as you've gone through this video, you've kind of learned that wills can be very complex and there are a lot of legal requirements around them. So let's talk for a moment about the pros and cons of having a will as part of your estate plan. Now, on the pro side, obviously, a will is tremendously flexible. It gives you control of your property up until the very moment that you pass away. So you have complete ownership of your property. You don't have to share it with anyone. You can change your will anytime. Ultimate in flexibility, right? Now, you can also direct your property to go anywhere. Contrast that with the default rules, the intestate succession rules, which states your property has to go to a surviving spouse, a child, or another family member. But if you want your property to go to a charity, to a religion, to any sort of community organization, you've got the power to do that in your will. You can give property in a will to almost anybody. You can select your own executor. You can pick who you want to have in charge of that. Contrast that with the intestate succession rules in which someone's going to be picked for you. You can name guardians for your minor children. That's very important, obviously, for lots of parents, especially for parents of minor children. And you have a will that does its job and then goes away. In other words, once the will has been through the probate process and the property is allocated, it's no longer binding on anyone else. It's done its job and it goes away. So that makes it good for handling end-of-life property transfers, but it doesn't really operate long-term, and we'll talk about that here in just a second. On the con side of wills, the thing that people have often worried about wills is that they have to go through the probate process, and that's true. Wills do have to go through the probate process. That's difficult. It can take some time, it can take some money, and it means that wills can be easily contested. Like we talked about, if someone doesn't like what they received under the will, they'll contest the execution or they'll contest the capacity of the person that made it. So that makes them a little bit more fragile than other instruments like trusts, for example. The probate process takes time and it takes money. Like we said, at its very best, the probate process is going to take several months, and quite frequently it will last for a year or more. And some people may not be willing to have their property held up that long. That can be really difficult for farms and ranches, which obviously have to be maintained throughout the year. And the probate process can complicate that somewhat. Now, again, probate is state specific, meaning if I have property in multiple states, my will has to be probated in all those states. And in contrast to documents like trusts, for example, wills do their thing and then go away. If it's really important to me that my land has to stay within the family, or that it has to be operated as a farm, and that it can't be transferred in some way, another instrument like a trust might be a better tool, because trusts can last for a much longer time. The will does its job and then it's gone. So to review what we've talked about today, we've talked about the will being a set of instructions for how we distribute someone's property after they've died. We've talked about the number of execution requirements that all have to be satisfied for the will to be valid. We talked about testamentary capacity, what it takes to have it, and how that may be an important grounds if someone is trying to contest the will later down the road. We've talked about the probate process, what the steps are, and what the executor has to do along each of those steps. And we've talked about the advantages and disadvantages of wills. Now, as you've probably seen from what we've discussed, wills can be a tremendously flexible tool, and they're probably going to be part of the tool set that you use not only as your estate plan, but as part of your larger farm transition plan. But there are lots of other things to think about, lots of considerations to go into making your will, and we've included resources for that and all the other topics in the Farm Transition series. They're all available for you along with the other videos in the series at this website, agecon.okstate.edu/farmtransitions. Thanks for your attention today. I've been Shannon Farrell with the OSU Department of Agricultural Economics.